Hey guys and gals, Todd Vandermyde back here for another edition of Freedom Steel. Your former NRA contract lobbyist, Illinois gun law guru. We survived Whiskey Wednesday yesterday, which also happened to be National Margarita Day. So I took the wife out for a couple of margaritas at our favorite local Mexican joint. Did that, but we are back at it. So, first off, just want to remind everybody that with all the litigation going on and with the Illinois Gun Rights Association, that the coalition of groups fighting the semi-auto ban and looking to take on other issues is important. So links are below. Please donate whatever you can, whether it's a sawbuck or more. Every bit is appreciated. The Second Amendment Defense and Education Committee that was set up is now a 501c3. So please, if you want to make a big donation, it is tax deductible over there. But you've got FFL Illinois, so if you're an industry guy, donate over there. You can take that off as a business expense for dues or whatever. You also, but don't take me for tax advice. I'm not a tax attorney, okay? But getting into all that not so good news today. Yesterday, received an order from the court in Cook County on the case that's named after me, Vandermyde versus Cook County, on the Cook County revised ammo tax. So we got that, and so it's a two-page order. It is a short decision. And so I'm just going to read to you the decision so you can get it. But defendant's motion, that's Cook County, to dismiss is granted because the First District Appellate Court already determined that these additional county taxes on the purchase of guns and ammunition do not infringe upon any protected Second Amendment right under the United States Constitution and Gun Save Life, Inc. v. Ali. As such, the plaintiffs cannot state a claim upon which relief can be granted under 735 ILCS 5/2-615. Further, this court finds that the First District decision was not overturned by Gun Save Life, where the Illinois Supreme Court reversed on state constitutional grounds. In fact, the Illinois Supreme Court explicitly stated it need not consider the federal constitutional claims because the decision was made based on the state's uniformity clause. The court also agrees with arguments and case law cited by the defense and finds that the First District's decision was not directly abrogated by United States Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin. In that case, the United States Supreme Court eliminated the second prong of a two-part test historically used to analyze constitutional challenges to the Second Amendment, determining that the second step was one step too many. Bruin, however, did not eliminate the first part of the test, and the First District Appellate Court, consistent with Bruin, made its determination based on the first prong of the test, Gun Save Life v. Ali. After analyzing the text of the Second Amendment, the Appellate Court found that taxes at issue did not restrict ownership of firearms or ammunition. This court is bound by the First District Appellate Court decision in Gun Save Life, Inc. v. Ali, and therefore this court grants defendant's motion to dismiss with prejudice. So, signed Judge Eve Riley. So she has dismissed this case, and with prejudice, meaning we can't refile this case in the district court. However, we are going to appeal this case, and I would let you know that when I got asked to be part of this case, I insisted on being able to have a say in the briefs. And in the briefs I edited, we brought up the New York decision. I thought that would be a game changer, but evidently this judge hasn't taken any time to really read the New York decision. And so with that, just punted. I mean, it's a short order. There is no finding of fact. There is, New York doesn't apply. Oh, the First District Appellate Court actually, under their historical analysis, this doesn't apply. I'm going to go back and reread that First District case from Gun Saves Life, but I'm going to beg to differ with them. because the test that was enumerated is, does this qualify? Does this impact the right to keep and bear arms? Yes, it makes it more expensive. It makes it more expensive to acquire, to train, to practice. Therefore, the first prong of the test is met. Now it shifts to the government to come up with a historical analogy. I wonder if Cook County is going to be so stupid as to bring up the Boston Tea Party and talk about the taxes levied on tea back at the time. But we'll see. So with this, not a great decision, cuts against us, but I mean, this decision's 2 pages long. That's it. It isn't any more than that. And it was brought in state court. It's class action eventually, but it'll get appealed up. And this may be the first real shot to get to the Illinois Supreme Court with a Bruin challenge, a New York challenge, and have the court take notice on how they're going to have to reframe their former debates and discussions, because they sat there and brought up, they were using the 2-part test from the Seventh Circuit previously. This is why we brought in New York. There is a Second Amendment claim here. And I'm kind of surprised Cook County didn't want to bring this up into the federal courts like the AG has done on other stuff. But with that, we're going to go forward. We're going to move forward on this. We're going to bring in some heavy hitters on this. And if you've seen the briefs that are going around and the responses to the California stuff, is how the state's not making their case, all the things that are going on with how the test is applied, what New York actually means. I mean, you can just strike out some of that, and it's, you're going to see these intense briefs as to how this district court got it wrong. And we will go on from there. It's going to be interesting. It's going to be a fun little fight here. Unlike the last Cook County case with Gun Save Life and Maxons and all those guys that took somewhere in the neighborhood of 7 years. I mean, this was filed in June of last year prior to New York, and now we are on here and, 5 months later, we've got a decision. So now on up to the appellate court, and we'll see if they're going to get any smarter or if we're going to have to go to the Illinois Supreme Court, and we'll see if they've gotten any better since we now have 2 new judges up there. Going to be interesting. So with that, as always, ladies and gentlemen, it's always good to talk to you guys. Sometimes I wish I had some better news. We will have a status call on the 4 Southern Illinois gun ban cases tomorrow. Got a big stack of stuff here to work through. Going to try to cut some more vids and post them later. But as always, guys, please like, subscribe, copy, share the links, post them around to all your social media. Our numbers are growing. I'm seeing some old friends show up in the comments. Shout out to David and Colleen Lawson, part of the original McDonald case. With all that, guys, as always, frag out.